Imagine waking up tomorrow morning to find out that something you've legally owned for years could suddenly make you the target of a federal investigation. Not because you committed a crime, not because you sold dozens of firearms, not because you were running some secret business, but because you sold one firearm from your personal collection and a government agency decided that single transaction looked suspicious enough to classify you as a firearms dealer. Sounds impossible, right? Well, for millions of gun owners across America, that wasn't a hypothetical situation. It was a very real threat. And just a few days ago, everything changed. A federal court delivered what many legal experts are calling one of the most significant defeats the ATF has suffered in modern history. A decision so sweeping, so direct, and so damaging to the agency's position that gun owners from California to Florida are feeling the impact immediately. Yet despite the magnitude of this ruling, most Americans have no idea it happened. The evening news barely mentioned it. Major networks moved on within hours. And while millions of lawful firearm owners went about their daily lives completely unaware, one of the biggest legal battles over gun rights in recent years came to a dramatic conclusion. The reason this matters is simple. This wasn't a case about criminals. It wasn't a case about violent offenders. It wasn't even a case about people trying to exploit loopholes in the law. This case was about ordinary Americans, hunters, veterans, competitive shooters, collectors, fathers passing firearms to sons, grandfathers selling a rifle they no longer use. Everyday citizens who believed they were following the law exactly as Congress wrote it. But according to a controversial federal rule, that understanding was no longer enough. For decades, Americans operated under a relatively straightforward principle. If you owned firearms as part of your personal collection, you could generally sell, trade, or transfer them under the rules established by federal and state law without automatically becoming a federally licensed firearms dealer. That distinction mattered because becoming a dealer comes with an entirely different set of obligations, regulations, paperwork requirements, inspections, and legal risks. The line between a private citizen and a commercial dealer had existed for generations. Then everything started to change. A new interpretation emerged that dramatically expanded how the government viewed private firearm transfers. Suddenly, activities that many gun owners considered normal could potentially be viewed through a completely different lens. The concern wasn't necessarily how many firearms someone sold. The concern was why they sold them. And that's where things became deeply controversial. Imagine selling a handgun to help fund the purchase of another firearm. Imagine trading a rifle you no longer wanted. Imagine listing a firearm online because you needed extra money for home repairs, medical bills, or family expenses. Under the government's interpretation, actions like these could potentially be used as evidence that you were engaged in business activities that required federal licensing. Think about that for a moment. Not 20 sales, not 50 sales, not hundreds of sales. One transaction could potentially become the basis for scrutiny. One transaction. For many Americans, that possibility was shocking. Because suddenly, the question wasn't whether you were operating a firearms business. The question was whether a federal agency could decide you were operating a firearms business after the fact. That distinction became the center of a legal fight that would eventually reach one of the most important moments in modern firearms litigation. Gun owners across the country began asking the same question. If Congress never passed a law saying one private sale turns someone into a dealer, where did this authority come from? Who gets to decide what the law means? Congress or a federal agency? Those questions eventually landed in federal court, and when they did, the outcome was far more dramatic than many people expected. Organizations representing gun owners, constitutional advocates, industry groups, and ordinary citizens joined forces to challenge what they believed was an unprecedented expansion of federal power. Their argument was surprisingly simple. Congress writes laws. Federal agencies enforce laws. Agencies do not get to create entirely new legal obligations simply because they prefer a different policy outcome. That principle may sound technical, but it sits at the heart of how the American government is supposed to function. And as the case moved through the legal system, it became increasingly clear that the stakes extended far beyond firearms. Because if a federal agency could redefine one law through interpretation, critics argued, what would stop agencies from redefining countless others? By the time appellate judges began reviewing the case, attention from legal scholars, constitutional experts, and Second Amendment advocates had intensified dramatically. Everyone understood that the decision could affect millions of Americans. Not just firearm owners, but anyone concerned about how much authority federal agencies should possess when interpreting laws passed by Congress. Then the ruling finally arrived, and when it did, it sent shockwaves throughout the legal community. The court didn't merely disagree with the agency's position, it rejected it, forcefully. The judges concluded that the agency had gone beyond the authority granted by Congress and attempted to create obligations that did not exist in the law itself. In language that immediately grabbed headlines across the legal world, the court described the rule as an overreach that could not stand. But what happened next was even more important. Because the court didn't simply criticize the rule, it stopped it, nationwide. Not in one state, not in one region, not for a limited group of plaintiffs, nationwide. That meant the consequences extended immediately to gun owners in every corner of the country. For the first time in months, millions of Americans who had been uncertain about how future transfers might be interpreted suddenly had clarity. And that clarity represented far more than a courtroom victory. It represented a reminder of something fundamental. In America, agencies do not write laws. Congress writes laws. And when agencies attempt to stretch their authority beyond what lawmakers intended, courts still have the power to step in and draw a line. The real question now is what happens next. Because while this ruling delivered a major victory for gun owners, it also signals something much bigger taking place inside the federal court system. A shift that is reshaping firearms litigation across the country and producing outcomes that would have seemed impossible only a few years ago. And once you understand what's driving that shift, you'll understand why many legal analysts believe this story is only the beginning. What makes this ruling so important isn't just the fact that the ATF lost. Agencies lose cases from time to time. Regulations get challenged, policies get overturned. That happens. What makes this different is the message the court sent. The judges weren't simply saying they disagreed with one particular rule. They were reminding every federal agency in America that there are limits to their power. Limits that cannot be crossed simply because officials believe a different policy would be better. And for millions of gun owners, that distinction could not be more important. Think about the uncertainty that existed before this decision. Imagine being a law-abiding firearm owner who spent years building a personal collection. Maybe you've inherited firearms from family members. Maybe you've purchased a few over the years for hunting, sport shooting, home defense, or collecting. Then one day you decide to sell one of them. Not because you're starting a business, not because you're opening a gun shop, simply because you no longer need it, or because you're interested in purchasing something else. Under the interpretation being challenged, that ordinary transaction suddenly carried risks that many Americans never imagined possible. And that uncertainty wasn't theoretical, it was real. Across the country, gun owners were asking the same questions. Could selling a firearm from my collection create legal problems? How many sales are too many? What if I trade a firearm with another collector? What if I sell one firearm to help finance another purchase? Where exactly is the line? The problem was that nobody seemed able to provide a clear answer. And whenever ordinary citizens cannot clearly understand what behavior is legal and what behavior is illegal, something has gone wrong. The law is supposed to provide clarity. People should be able to read it and understand their responsibilities. They should not have to guess. They should not have to wonder whether an agency might reinterpret their actions years later and decide they violated rules they never knew existed. That concern became one of the central themes of the case. The judges recognized that the government was attempting to expand its authority in ways that Congress had never explicitly authorized. In doing so, they reaffirmed a principle that reaches far beyond firearms. The federal government cannot simply create new crimes through interpretation. It cannot transform ordinary citizens into lawbreakers by changing definitions after the fact. If lawmakers want new restrictions, new requirements, or new obligations, Congress must pass them through the legislative process. For many Americans, that principle may sound obvious, but recent years have shown that it cannot be taken for granted. That's one reason this decision is generating so much attention among constitutional scholars. While gun owners are understandably focused on the Second Amendment implications, legal experts see something even larger. They see a growing trend in which courts are becoming increasingly skeptical of federal agencies attempting to expand their own authority. They see judges asking tougher questions. They see a judiciary that is less willing to accept broad interpretations that were once routinely approved. And nowhere has that trend become more visible than in firearms cases. Over the last several years, a series of legal battles has fundamentally changed the landscape. Cases that once would have been dismissed are now receiving serious consideration. Arguments that once struggled to gain traction are winning in courtrooms. Long-standing assumptions about how firearms regulations are evaluated have been challenged, reconsidered, and in some cases, completely overturned. This latest ruling didn't happen in isolation. It is part of a much larger shift. A shift that began when courts started re-examining how constitutional rights should be analyzed. For decades, many gun owners felt as though the Second Amendment was treated differently than other constitutional protections. Restrictions were often upheld with relatively little scrutiny. Agencies enjoyed broad discretion. Regulators were given significant room to interpret laws as they saw fit. Critics argued that this created an environment where bureaucratic power continued expanding while constitutional protections continued shrinking. Now, many believe that trend is reversing, and if that's true, the implications could be enormous. Because the challenge facing federal agencies today isn't limited to one rule or one regulation. Courts are increasingly asking a fundamental question. Where is the historical foundation for these restrictions? If a modern regulation has no meaningful historical equivalent, can it really survive constitutional scrutiny? That question is forcing judges, lawyers, and regulators to revisit assumptions that stood largely unchallenged for years. The result has been a series of courtroom defeats that few people would have predicted a decade ago. And every one of those defeats sends a signal. A signal to regulators that the rules have changed. A signal to lawmakers that constitutional rights still matter. And perhaps most importantly, a signal to ordinary Americans that courts are paying attention. That's why many legal analysts believe this ruling could have consequences that extend far beyond private firearm transfers. Future challenges are already moving through the court system. Some involve firearm classifications, others involve licensing requirements, others challenge restrictions that have existed for generations. While nobody can predict how every case will end, one thing is becoming increasingly clear. The legal battles shaping the future of gun rights are far from over. In fact, many experts believe we're only in the early chapters of a much larger story. Because once courts begin drawing clear boundaries around agency authority, those boundaries don't just affect one case. They affect every future attempt to expand regulatory power. They establish precedents. They create legal roadmaps. They provide future litigants with powerful arguments and powerful tools. And that's exactly why supporters of this ruling are celebrating. Not because one case was won, but because they believe the principles behind the decision could influence countless cases still waiting to be decided. The real question now is what federal agencies do next. History suggests they won't simply walk away. Agencies rarely surrender authority voluntarily. When one strategy fails, they often search for another. When one regulation gets struck down, a revised version sometimes appears. When one legal pathway closes, another may open. That means today's victory could easily become tomorrow's new legal battle. And if that happens, the people who stay informed will be the people best prepared to protect their rights. Because whether you support stricter gun laws, oppose them entirely, or fall somewhere in between, one reality remains unchanged. Decisions made in federal courtrooms have the power to affect millions of Americans long before those Americans even realize a change has occurred. And judging by the cases already moving through the system, some of the biggest decisions may still be ahead.